I was standing in my driveway on a freezing January morning in Rochester, Minnesota, watching the city plow rumble past my house when I heard the screech of tires followed by the unmistakable crunch of metal against ice. My name is Yates Xavier, and I had just become the unwilling star of what would turn into the most absurd legal battle of my life. The silver Mercedes SUV had skidded directly into the massive snow pile at the edge of my property. The one I had spent 3 weekends carefully building up from all the snow I had cleared from my driveway and sidewalks. The impact sent a shower of white powder into the air, and when it settled, I could see the front end of the vehicle was thoroughly wedged into my handiwork. Steam rose from the crumpled hood. I jogged over, my boots crunching through the fresh snow, already pulling out my phone to call for help. But before I could dial, the driver's door flew open with such force I thought it might snap off its hinges. Out stepped Karen Livingston, the 47-year-old vice president of our homeowners association, dressed in a cream-colored wool coat that probably cost more than my monthly mortgage payment. Her blonde hair was styled in that specific bob cut that seemed to be standard issue for HOA board members, and her face was already red with rage. "What the hell is this?" she shrieked, gesturing wildly at the snow pile. "Why would you put this here? Are you trying to kill someone?" I blinked, momentarily stunned by the accusation. "Karen, are you okay? Do you need me to call an ambulance?" "Don't you dare patronize me, Yates," she snapped, pulling out her own phone. "I'm calling the police and my lawyer. This is completely unacceptable. You've created a hazard on community property." "Community property," I repeated, my confusion growing. "Karen, that snow pile is on my property. It's a good 15 feet from the street." She waved her hand dismissively, her manicured nails flashing in the weak winter sunlight. "That's irrelevant. The HOA bylaws clearly state that anything visible from the street must meet aesthetic standards. Your pile of snow is an eyesore and apparently a safety hazard." I looked at the pile, then at her car, which was clearly far up onto my property. The street was at least 20 feet away. She had driven across the snow-covered grass buffer, over the slight rise of my property line, and directly into the pile. This was not a case of the pile extending into the road. This was a case of her driving where she had no business driving. "Karen, you drove onto my property and hit my snow pile. I don't understand how this is my fault." "Of course you would say that," she said, her voice dripping with contempt. "I was simply trying to make a turn and your snow pile was blocking my view. It's a menace." I could have been seriously injured. The police arrived within 10 minutes, and I was grateful to see Officer Mark Harrison step out of the patrol car. Mark and I had gone to high school together, and while we were not close friends, he knew me well enough to know I was not the type to create problems in the neighborhood. "Yates, Karen." He greeted us both with professional neutrality. "What happened here?" Karen immediately launched into her version of events, complete with dramatic hand gestures and several mentions of her position on the HOA board. According to her, I had maliciously placed a dangerous snow pile in a location specifically designed to cause accidents, and she was lucky to be alive. When she finally paused for breath, Mark turned to me. "Your side, Yates." "I built a snow pile on my own property from the snow I cleared off my driveway. It's been there for 2 weeks. Karen drove onto my property and hit it. That's the whole story." Mark walked around the scene, taking photos and measurements. He examined the tire tracks, which clearly showed Karen had left the road, crossed the grass buffer, and driven up onto my property before impact. He took more photos of the property lines, which were still visible despite the snow. "Mrs. Livingston," Mark said carefully, "your tire tracks show you left the roadway and drove onto Mr. Xavier's property before the collision. Can you explain why? Karen's face turned an even deeper shade of red. I was making a turn. His snow pile blocked my sight line. But you were not in the road when you hit the pile. You were on his property. That's semantics, Karen huffed. The fact remains that his pile is a hazard and should never have been there in the first place. Mark sighed and finished his report. I'm not issuing any citations today. This appears to be an accident on private property. You'll need to exchange insurance information and work this out between yourselves. Karen's eyes went wide with disbelief. You're not going to cite him for creating a hazard. There's no law against having a snow pile on your own property, Mrs. Livingston. If anything, you were driving on property that's not yours. After Mark left and the tow truck arrived to extract Karen's Mercedes from my snow pile, she stood on the sidewalk with her arms crossed, watching them work. I had retreated to my front porch, but I could still hear her on her phone, presumably calling every board member she could reach. This is not over, she called out to me before climbing into her husband's truck, which had arrived to pick her up. You're going to pay for my damages, and the HOA is going to make sure you never pull something like this again. I just waved and went back inside my house, shaking my head. I had lived in the Meadowbrook Hills subdivision for 6 years, and while I had heard stories about HOA disputes getting out of hand, I had always managed to stay under the radar. I kept my lawn mowed, my house painted in approved colors, and my trash cans stored out of sight. I paid my dues on time and never attended the meetings because they seemed like exercises in neighborhood gossip and petty power trips. That was about to change. 3 days later, I received a certified letter from the HOA's legal counsel, a firm called Berkman and Associates. The letter informed me that I was in violation of Section 7.3 of the HOA bylaws, which stated that no homeowner shall place, construct, or maintain any structure or obstruction that creates a hazard or diminishes the aesthetic value of the community. The letter demanded I remove the snow pile immediately and pay for all damages to Karen Livingston's vehicle, totaling approximately $8,000. I read the letter 3 times, each time growing more incredulous. They were actually trying to hold me responsible for damage caused when someone drove onto my property and hit something that was entirely within my property lines. I called my insurance company first. My agent, a patient woman named Sandra, listened to my story and pulled up the police report. Yates, based on this report, you're not at fault. She drove onto your property. We're not paying her claim. She's demanding I pay directly. She can demand whatever she wants. That doesn't mean you owe it. If she tries to sue you in small claims court, make sure you show up with all your documentation. But honestly, I don't think she has a case. Next, I called a lawyer. I had never needed legal representation before, and the process of finding someone felt overwhelming. After several phone calls and consultations, I settled on Robert Mayers, a real estate attorney who had experience with HOA disputes. Robert was in his late 50s, with gray hair, and the kind of calm demeanor that suggested he had seen every type of nonsense imaginable. We met in his office on a Tuesday afternoon, and I brought copies of everything: the police report, photos of the scene, the HOA letter, my property survey, and the HOA bylaws. He reviewed everything methodically, making notes on a yellow legal pad. When he finished, he sat back in his chair and steepled his fingers. "They don't have a case," he said simply. "The snow pile was on your property. She drove onto your property. The police report supports this. The bylaw they're citing doesn't apply because a temporary snow pile is neither a structure nor an obstruction in the legal sense. So, what do? You write back declining their demand. You make it clear that you were not at fault and that they should pursue their claim through proper insurance channels. And you document everything from this point forward, because HOA boards can be vindictive when they don't get their way. Robert helped me draft a response letter. It was professional and firm, citing the police report and the clear evidence that Karen had been operating her vehicle on my property at the time of the accident. We sent it certified mail, and I thought that might be the end of it. I was wrong. The following week, I received a notice that the HOA board was holding a special hearing regarding my violations, and that my presence was mandatory. The hearing was scheduled for a Thursday evening at the community center. "Do I have to go?" I asked Robert over the phone. "You don't have to, but I'd recommend it. HOA boards have certain powers, and if you don't show up to defend yourself, they might levy fines or other penalties that could become a lien on your property. It's better to face this head-on." So Thursday evening found me sitting in the community center, a bland beige room with fluorescent lights, and a folding table at the front where the 5 board members sat like judges. Karen was there, naturally, looking smug. The president, a retired accountant named Donald Parsons, was a thin man with wire-rimmed glasses who looked like he took his position far too seriously. The other members were Linda McCarthy, treasurer, Jorge Ramirez, secretary, and Patricia Holden, member-at-large. About 15 other homeowners had shown up, probably drawn by gossip about the incident. I recognized most of them by sight, though I knew few by name. Donald called the meeting to order with a sharp rap of his gavel. "We're here tonight to address violations by homeowner Yates Xavier, property address 2847 Windridge Lane. Mrs. Livingston, as the complainant, please present your case." Karen stood, smoothing down her skirt. She had prepared notes, which she read from in a voice that managed to sound both wounded and indignant. "On January 15th, I was performing my duties as vice president of this board, conducting a routine drive-through of the neighborhood to check for violations, when I was involved in a serious accident. Mr. Xavier had placed an enormous pile of snow on his property in a location that created a hazard. The pile blocked sight lines for vehicles and pedestrians and was an eyesore that violated our community standards. When I attempted to navigate the corner near his property, the pile caused me to lose control of my vehicle, resulting in significant damage and potential injury. Mr. Xavier has refused to take responsibility for his reckless actions and has declined to pay for the damages he caused. This is exactly the kind of selfish behavior that degrades our community and puts all of us at risk." She sat down to murmurs from the crowd. I could not tell if they were sympathetic or skeptical. Donald turned to me. "Mr. Xavier, your response." I stood, holding my folder of documents. "I'd like to submit copies of the police report from the incident for the board's review." I passed out copies to each board member. They took several minutes to read through the report, and I watched their expressions carefully. Linda and Jorge seemed puzzled. Patricia looked uncomfortable. Donald remained neutral. Karen looked annoyed. "As you can see from Officer Harrison's report," I continued, "the snow pile was entirely on my property, approximately 18 feet from the edge of the public road. Mrs. Livingston's tire tracks clearly show she left the road and drove onto my property before striking the pile. The officer found no violations and issued no citations. My insurance company has reviewed the case and confirmed I was not at fault. The snow pile was a temporary accumulation of snow from my own driveway, which is a normal and legal winter activity. I have not violated any HOA bylaws." Karen shot to her feet. "That's absurd. The pile was obviously a hazard." Just because I had to leave the road to investigate properties for violations does not mean you can place dangerous obstacles wherever you want. You were not investigating my property, I said, keeping my voice level. You were driving across my lawn and hit something that was clearly visible and entirely within my property boundaries. Mr. Xavier, Donald interrupted, do you have a survey showing your property lines? I handed over copies of my property survey, which I had ordered from the county records office. It clearly showed the boundaries of my lot and the location of the snow pile, which I had marked based on measurements I had taken after the accident. The board members studied the documents, passing them back and forth and whispering to each other. This went on for nearly 10 minutes while the audience watched in silence. Finally, Donald cleared his throat. Mr. Xavier, while we acknowledge that the snow pile was technically on your property, we believe it still represents a violation of community standards under Section 7.3 of the bylaws. The board has the authority to determine what constitutes an aesthetic violation or hazard. With respect, I said, that section does not apply to temporary natural accumulations like snow. If that were the case, everyone in the neighborhood would be in violation every time it snows. But you deliberately piled the snow in that location, Karen interjected. It was not natural. I piled snow from my own driveway onto my own property. That's what everyone does with snow they clear. Jorge raised his hand tentatively. I have a question. Do we have any other complaints about snow piles in the neighborhood? Because I have one on my property too, and so do most of the homeowners here. Karen shot him a withering look. That's different. Your pile is not creating a hazard. But how is it different? Jorge pressed. It's the same thing. We all pile snow somewhere. Because mine was not struck by a vehicle, Jorge said simply, and several people in the audience laughed. Donald banged his gavel. Order. The board will take this matter under advisement and issue a ruling within 5 business days. This hearing is adjourned. I left the community center feeling frustrated. The whole thing was ridiculous, but Robert had warned me that HOA boards often operated on emotion and politics rather than logic and law. 5 days later, I received the board's decision. By a vote of 3-2, they had found me in violation of Section 7.3 and ordered me to pay a fine of $500. They also issued a formal demand that I remove any future snow piles from areas visible from the street and pay for Karen's vehicle damages. I immediately forwarded the decision to Robert. They're overreaching, he said when we spoke. They cannot force you to pay for damages caused by someone else driving onto your property. As for the fine, we can challenge it. The bylaw they're citing simply does not apply to your situation. But you need to know that fighting this could get expensive and time-consuming. How expensive? If we go to court, you're looking at several $1,000s in legal fees, maybe more if it drags on. On the other hand, if you just pay the $500 fine, this might go away. I thought about it for a long moment. $500 was a lot of money to me. I worked as a mechanical engineer for a medical device company, and while I made a decent living, I was not wealthy. But the principle of the thing galled me. I had done nothing wrong. What about Karen's demand for the vehicle damages? I asked. Ignore it. That's a civil matter between her and you, and she would have to sue you in court to collect. Based on the evidence, I don't think she would win, but she might try anyway. I decided to fight the HOA fine. Robert helped me file an appeal with the board, which they denied. Then we took it to mediation, as required by Minnesota law before filing a lawsuit. The mediation took place in a conference room at a neutral location. The mediator was a retired judge named Helen Foster, a no-nonsense woman in her 70s who made it clear she had little patience for foolishness. The HOA was represented by their attorney, Frank Berkman, a slick man in an expensive suit who talked a lot but said very little of substance. Donald and Karen attended as representatives of the board. We each presented our case. Frank argued that the HOA had broad authority to enforce community standards and that the board's decision should be respected. Robert countered with the police report, the property survey, and a detailed analysis of why Section 7.3 did not apply to temporary snow accumulation on private property. Judge Foster listened to both sides, asked pointed questions, and finally sat back with a sigh. "Here's what I think," she said. "The HOA is stretching their authority to fit a situation that does not logically fall under their bylaws. Mr. Xavier's snow pile was on his property and was a normal, reasonable response to a Minnesota winter. Mrs. Livingston drove onto his property and hit the pile. That's not Mr. Xavier's fault or responsibility. However, I understand the board feels they need to maintain standards in the community." She looked at both parties. "I propose a compromise. The HOA drops the fine and withdraws the demand for damages. Mr. Xavier agrees to try to keep future snow piles in less visible locations when possible, though with no formal requirement or penalty if he cannot. Everyone walks away, and we move on with our lives." I was ready to agree immediately, but Karen shook her head before I could speak. "Absolutely not. He needs to pay for what he did." Donald looked uncomfortable. "Karen, maybe we should consider the compromise." "No," she said firmly. "This is about principle. He's being difficult and uncooperative, and the community needs to see that we won't tolerate that." Judge Foster raised an eyebrow. "Mrs. Livingston, with all due respect, the evidence clearly shows Mr. Xavier was not at fault for your accident. Continuing to pursue this matter is likely to cost the HOA far more in legal fees than any fine you might collect." "We have insurance for legal fees," Karen said dismissively. "Actually," Frank interjected nervously, "our insurance does not cover lawsuits between the HOA and homeowners over matters like this." Karen glared at him. "Then we'll pay out of HOA funds. We have reserves." Robert leaned forward. "Those reserves are funded by all the homeowners, including my client. Is the board really prepared to spend thousands of dollars of community money to pursue a case they're likely to lose?" "We're not going to lose," Karen insisted. "The mediation ended without resolution." Judge Foster looked disappointed, but she prepared the paperwork indicating that mediation had failed and that we were free to pursue legal action. As we left the building, Robert turned to me. "She's going to sue you. I'd bet money on it, and the HOA might continue to pursue the fine. You need to be prepared for this to get messier." He was right. 2 weeks later, I was served with a lawsuit. Karen Livingston was suing me personally for $8,000 in vehicle damages, plus court costs and attorney fees. The lawsuit made wild claims about my negligent placement of a hazardous snow pile and my reckless disregard for the safety of community members. The HOA also doubled down, sending me a second notice that my fine had increased to $1,000 due to continued non-compliance, because I still had not paid the original fine. I met with Robert again, and we began preparing for court. This meant gathering more evidence, taking statements, and building a defense. Robert also suggested we file a counterclaim. "A counterclaim for what?" I asked. "Harassment, abuse of process, possibly defamation, depending on what she's been saying about you around the neighborhood. We can also go after the HOA for exceeding their authority and misusing homeowner funds. Won't that just make things worse? Possibly. But sometimes you need to push back hard to get people to back down. Right now, they think you're a soft target. If you show you're willing to fight, they might reconsider. We filed a counterclaim against Karen for abuse of process and against the HOA for breach of fiduciary duty and violation of Minnesota's Homeowners Association Act. We requested damages, attorney fees, and an injunction preventing the HOA from levying any further fines related to the incident. The neighborhood gossip mill went into overdrive. I started getting calls and visits from other homeowners, some offering support and others clearly trying to gather information they could take back to the board. One evening, my neighbor from across the street, Tim Walters, came over with a 6-pack of beer. "This whole thing is insane," he said as we sat in my living room. "Karen's telling everyone you're trying to destroy the HOA and ruin property values. By having a snow pile, by being difficult, according to her. She's making it sound like you're some kind of rebel trying to undermine community standards. All I did was pile snow on my own property and she crashed into it. I know, man. Most people know. But Karen's got Donald wrapped around her finger and they control the board. Linda and Jorge are too scared to stand up to them. What about Patricia?" Tim shrugged. "She just goes along with whatever seems easiest. She's not a troublemaker." As spring approached, the legal process ground forward. We had a preliminary hearing where the judge reviewed the basic facts of the case. Judge Andrea Martinez was a sharp woman in her early 50s who seemed unimpressed with Karen's lawsuit. "Mrs. Livingston," she said, flipping through the police report. "This report indicates you drove onto the defendant's property before striking the snow pile. Is that correct?" Karen's attorney, a young man named Paul Dietrich who seemed overwhelmed by the case, nodded. "Yes, Your Honor, but my client was acting in her official capacity as an HOA officer conducting inspections. Does her official capacity give her permission to drive across private property? Well, she was not intentionally driving on his property. The snow pile caused her to lose control of her vehicle. Before she struck the pile, according to these tire track measurements in the report, so she was already on his property when she allegedly lost control." Paul shuffled his papers. "The exact sequence of events is disputed." "It doesn't seem disputed in this police report, which your client gave a statement for at the time of the incident." Judge Martinez set a trial date for June and strongly suggested both parties consider settlement. "This seems like a case that's wasting everyone's time and money," she said bluntly. After the hearing, Paul approached Robert in the hallway. "Is your client willing to settle?" "We've been willing to settle from the beginning," Robert said. "Drop all claims, drop the HOA fine, and we'll drop our counterclaims. Everyone walks away. My client wants compensation for her vehicle. Your client drove onto my client's property and crashed. That's not his responsibility. She feels very strongly about this." "Then I guess we'll see each other in court." As the trial date approached, Robert and I prepared extensively. We had photographs, measurements, witness statements from neighbors who had seen Karen driving erratically through the neighborhood on other occasions, and even weather reports showing that visibility was good on the day of the accident. We also discovered something interesting during discovery. Karen had filed 3 previous insurance claims for vehicle accidents in the past 5 years, all of which she had blamed on other people or circumstances. In one case, she had claimed a shopping cart had rolled into her car in a parking lot, even though security footage showed she had backed into a stationary cart. The insurance company had denied that claim. "This establishes a pattern," Robert explained. "She has a history of causing accidents and trying to blame others. That's going to be useful." Meanwhile, the HOA situation was deteriorating. They sent me monthly notices about the unpaid fine, which now included late fees and interest, bringing the total to over $1,500. They also started finding other violations on my property. My mailbox was apparently painted the wrong shade of black. My front door wreath was not on the approved decorative items list. My garbage cans were visible from the street for 14 minutes longer than the allowed time on trash collection day. Each violation came with its own fine. They were clearly trying to pressure me into backing down. Other homeowners began experiencing similar treatment. Tim got cited for having his car parked on the street overnight, even though there was no rule against that and half the neighborhood did it regularly. Jorge got a violation notice for having a garden gnome in his yard. The neighborhood Facebook group exploded with complaints about the board's behavior. A group of about 20 homeowners, fed up with the increasingly aggressive enforcement, started organizing. They called themselves the Meadowbrook Hills Reform Coalition, and their goal was to recall the board members at the next election and install new leadership. I attended one of their meetings, held in someone's basement. The energy was angry and determined. "They're out of control," said Michelle Chen, an accountant who lived 2 streets over. "This is supposed to be a homeowners association, not a dictatorship. They work for us, not the other way around. The problem is that most people don't vote in HOA elections," Tim pointed out. Karen and Donald got elected because only about 30 people voted and they rallied their friends. "Then we need to make sure everyone votes this time," Michelle said. "The election is in August. That gives us a few months to organize." I appreciated their efforts, but I was focused on the upcoming trial. Robert had warned me that even though we had a strong case, you could never predict what would happen in court. The trial began on a humid morning in June. The courtroom was smaller than I expected, and besides the lawyers and principals, only a handful of people were present. Tim had taken the day off work to support me, and a couple of other neighbors showed up out of curiosity. Karen was dressed conservatively in a navy suit, and she had clearly been coached to appear sympathetic. She dabbed at her eyes with a tissue as Paul gave his opening statement, painting a picture of her as a dedicated volunteer who had been injured in the line of duty by my reckless behavior. Robert's opening statement was direct. "This is a case about personal responsibility. Mrs. Livingston drove her vehicle onto Mr. Xavier's property and struck a pile of snow that was clearly visible and entirely within property boundaries. She now wants Mr. Xavier to pay for her mistake. The evidence will show that not only was Mr. Xavier not at fault, but that Mrs. Livingston has a pattern of causing accidents and blaming others." Paul called Karen as his first witness. She testified about her years of service to the HOA and her dedication to maintaining community standards. She described the day of the accident, claiming she had been carefully driving through the neighborhood when the snow pile had suddenly appeared in her path, causing her to swerve and lose control. "It was terrifying," she said, voice quavering. "I thought I might be killed." And then Mr. Xavier showed no concern for my well-being. He was only worried about his precious snow pile. On cross-examination, Robert was methodical and devastating. "Mrs. Livingston, you testified that the snow pile suddenly appeared in your path. But the pile had been there for 2 weeks before the accident, correct? I don't drive down that street every day. But you drive through the neighborhood regularly as part of your HOA duties, correct?" "Yes." "So you had likely seen the pile before." "I don't recall." Robert pulled out a photograph. "This is a photo taken from the street looking at Mr. Xavier's property. You can clearly see the snow pile. It was approximately 7 feet tall and 15 feet across. Does that help refresh your memory about whether you might have seen it before?" "It's possible I saw it. And on the day of the accident, the weather was clear and sunny with good visibility, correct, I suppose? So there's no reason you would not have seen a 7-foot-tall pile of snow. It was the placement of it. It blocked my sight line. Mrs. Livingston, let me show you the police diagram of the accident scene. According to this, you left the roadway, drove approximately 20 feet across snow-covered grass, and then struck the pile. Is that accurate? I was checking the property for violations. So you intentionally drove onto Mr. Xavier's property. I was doing my job. Does your job as vice president of the HOA give you the right to drive across private property without permission? I was not driving across it. I was just checking from different angles. From an angle that required you to leave the public roadway and drive 20 feet onto private property, Karen's face flushed. He should not have put the pile there. But he's allowed to put snow on his own property, correct? Not if it's a hazard. Is every snow pile in the neighborhood a hazard? His was in a dangerous location. Dangerous to people driving across his lawn, Paul objected, and Judge Martinez sustained it, but the point had been made. The gallery, small as it was, rippled with barely suppressed reactions. Robert then went through Karen's previous accident history, entering each insurance claim and the results into evidence. Paul objected repeatedly, but Judge Martinez allowed it as relevant to establishing a pattern of behavior. By the time Karen left the stand, she looked rattled and angry. Paul tried to recover with his next witness, an accident reconstruction expert who testified that the snow pile could have created a blind spot that might have caused Karen to misjudge her position. On cross-examination, Robert got the expert to admit that the blind spot would only be relevant to someone driving on the roadway, not someone who had already left the roadway and was driving across private property. In your expert opinion, Robert asked, if someone is driving on a lawn and hits an object on that lawn, is the object at fault? Well, that's a matter of legal interpretation, not engineering. But from an engineering standpoint, if you drive your vehicle into a stationary object, the cause of the collision is the vehicle's movement, not the object's presence, correct? Generally speaking, yes. When it was our turn, Robert called me to the stand. I testified about building the snow pile, measuring its location on my property, and the day of the accident. I explained that I had offered to help Karen immediately, and that she had immediately started blaming me and threatening legal action before even checking if she was injured. Paul's cross-examination tried to make me seem uncooperative and hostile to the HOA, but I kept my answers short and factual. Yes, I had disagreed with the board's ruling. No, I did not have a personal vendetta against Karen. I simply believed I was not responsible for an accident caused by someone else driving onto my property. Robert also called Officer Mark Harrison, who testified about the accident scene, and his conclusion that Karen had been operating her vehicle on private property at the time of the collision. In your professional opinion, was Mr. Xavier at fault for this accident? Robert asked. No, Mark said firmly. He had a snow pile on his own property. Mrs. Livingston drove onto that property and hit it. If anything, she could have been cited for trespassing or reckless driving, but I exercised discretion given that it appeared to be a simple accident. Paul tried to suggest that Mark was biased because we had gone to high school together, but Mark shut that down quickly. I've written reports on at least a dozen accidents involving people I knew personally, he said. I call it like I see it, regardless of who's involved. The evidence in this case was clear. The trial lasted 2 days. Closing arguments were straightforward. Paul argued that I had created a hazard and should be held responsible. Robert argued that Karen had driven onto my property and needed to take responsibility for her own actions. Judge Martinez took the case under advisement and said she would issue a written ruling within 2 weeks. Those 2 weeks were agonizing. I tried to focus on work and normal life, but the case consumed my thoughts. I had spent over $6,000 on legal fees so far, money I had not budgeted for and could not easily afford. If I lost, I would owe Karen another $8,000 plus court costs. The ruling came on a Wednesday afternoon. Robert called me at work and I stepped outside to take the call. "We won," he said, and I could hear the satisfaction in his voice. Complete victory. The judge ruled that Karen was entirely at fault, dismissed her lawsuit, and awarded us attorney fees and costs. She also ruled in our favor on the counterclaim, finding that Karen's lawsuit was frivolous and filed in bad faith. Karen has to pay you $12,000. I leaned against the building, feeling relief wash over me. What about the HOA fine? The judge issued an injunction against the HOA, preventing them from collecting the fine or levying any further penalties related to the snow pile incident. She found that they had exceeded their authority under the bylaws and violated Minnesota law by imposing fines for matters outside their jurisdiction. So it's over. The case is over. But you should read the judge's written opinion. She absolutely destroyed Karen's credibility and was pretty harsh on the HOA's conduct too. I got a copy of the opinion that evening. Judge Martinez had written a scathing 15-page decision that methodically dismantled every argument Karen and the HOA had made. She noted that snow accumulation on private property was a normal and necessary part of winter life in Minnesota, and that homeowners had every right to place snow anywhere on their own property. She found that Karen had been operating her vehicle in a reckless manner by leaving the roadway without justification, and that her subsequent attempts to blame Yates showed a disturbing lack of personal accountability. Regarding the HOA, Judge Martinez wrote that their actions appeared to be motivated by vindictiveness, rather than any legitimate concern for community standards. She noted that imposing fines for activities outside the scope of the bylaws violated Minnesota law, and that the board's escalating enforcement actions against Yates appeared to be retaliatory. The opinion concluded with a warning that if the HOA continued to pursue unwarranted actions against homeowners, affected parties should consider reporting the matter to the Minnesota Attorney General's office for investigation of potential misconduct. The neighborhood reaction was swift and dramatic. Copies of the opinion circulated through the Facebook group and email lists. The Reform Coalition used it as a rallying cry, printing excerpts and distributing them door to door. Karen and Donald tried to spin the loss, sending out a board email claiming that the judge had been biased and that they had fought valiantly for community standards. But the email only made things worse, as homeowners saw it as a refusal to accept responsibility. At the next HOA meeting, over 100 homeowners showed up, packing the community center beyond capacity. The mood was angry. People demanded explanations for why their HOA dues had been spent on a losing lawsuit. They wanted to know why the board thought it was acceptable to harass homeowners over trivial matters. Donald tried to maintain order, but the meeting devolved into chaos. Finally, Linda McCarthy, the treasurer, stood up and dropped a bombshell. "I think everyone deserves to know that the lawsuit cost the HOA $23,000 in legal fees," she said, her voice shaking. "That's money from all of you, money that could have been spent on community improvements or held in reserve for emergencies. Instead, it was spent on a lawsuit we never should have filed, pursuing a matter where we were clearly wrong." The room erupted. Karen tried to shout over the crowd, claiming Linda was betraying the board, but Donald just put his head in his hands. Jorge stood up next. "I'm resigning from the board effective immediately. I've been uncomfortable with the direction we've been taking and I should have spoken up sooner. I'm sorry to all of you. Patricia Holden followed suit. I resign as well. This has gotten out of hand. That left only Karen and Donald. The crowd started chanting for them to resign too. After 20 minutes of sustained pressure, Donald finally stood up and announced his resignation. Karen refused. "Someone has to maintain standards in this community," she said defiantly. "You're all acting like a mob." "You're acting like a tyrant," someone shouted back, and the room filled with applause. Without a quorum, the board could not conduct business. Michelle Chen stood up and proposed an emergency election to fill all board positions, to be held within 30 days as allowed under the bylaws. The motion passed by acclamation. Over the next month, the Reform Coalition recruited candidates and ran a genuine campaign. They held forums where candidates discussed their visions for the HOA. They distributed flyers and knocked on doors. Most importantly, they got people engaged who had never participated before. Election day in August saw a record turnout. Over 300 of the neighborhood's 450 households voted. The Reform Coalition candidates won in a landslide. Michelle Chen became president. Tim Walters became vice president. Linda McCarthy kept her position as treasurer. 2 other reasonable, level-headed homeowners filled the remaining seats. Karen did not even attend the election. According to rumors, she and her husband were considering moving to a different neighborhood, one where she might find a more receptive audience for her particular brand of governance. As for the financial judgment against her, Karen tried to avoid paying for several months. Robert had to file collection proceedings, and eventually, we received payment from her insurance company after they determined they had to cover it under her umbrella policy. I used part of the money to reimburse myself for the legal fees and paid off a chunk of my mortgage with the rest. It felt good to turn such a negative experience into something constructive. The new HOA board was a revelation. They reviewed all the bylaws and removed or clarified several vague provisions that had been abused by the previous board. They established clear procedures for violations and appeals, ensuring that homeowners had real due process. They focused on genuine community improvements like organizing neighborhood events and maintaining common areas, rather than nitpicking about mailbox colors. Most importantly, they remembered that an HOA was supposed to serve the homeowners, not rule over them. By the time the next winter rolled around, I was once again piling snow from my driveway onto the same spot on my property. This time, I even made it bigger, shaping it into a small sledding hill for the neighborhood kids. Several families brought their children over on weekends to slide down it. Tim came over one Saturday afternoon in January with his 2 kids. We stood watching them play, steam rising from our coffee mugs in the cold air. "Can you believe it's been a year?" he asked. "Barely. It feels like it all happened yesterday and a lifetime ago at the same time." You know, if Karen had just apologized and admitted she made a mistake, none of this would have happened. I know. She probably would have been out $1,000 insurance deductible and nothing else. Instead, she spent months on a lawsuit, cost the HOA $23,000, got herself and her allies thrown off the board, and ended up paying me $12,000. "Pride is expensive," Tim observed, "and snow piles are just snow piles." We laughed, and I felt genuinely content for the first time in months. The whole experience had been exhausting and frustrating, but it had brought the neighborhood together in an unexpected way. We had learned that we had power when we organized, and that we did not have to tolerate unreasonable behavior from people in positions of authority. The following spring, The HOA organized a neighborhood cleanup day followed by a potluck. Over 100 people showed up, and the sense of community was stronger than I had ever felt it before. People who had never spoken to each other were chatting and laughing. Kids ran around playing while adults worked together to spruce up the common areas. Michelle gave a short speech thanking everyone for their participation and for making the neighborhood a better place. "This is what an HOA should be," she said. "Neighbors helping neighbors, not neighbors fighting neighbors. We're all in this together." As I loaded trash bags into my truck, Karen and her husband drove past in a moving van, heading out of the neighborhood for good. She did not look in my direction, and I felt no animosity, only a kind of weary relief that the saga was finally, completely over. Later that evening, sitting on my porch with a beer, I reflected on everything that had happened. I thought about how a simple snow pile had turned into a months-long ordeal involving police reports, lawyers, trials, and neighborhood politics. I thought about how easily things could have gone differently if I had not stood my ground, if I had not had the resources to fight back, if Robert had not been such a good attorney, or if Judge Martinez had not been so willing to see through the nonsense. I thought about all the other homeowners living under unreasonable HOA boards, people who might not have the means or the support to push back against abusive authority. The experience had opened my eyes to a whole dimension of life I had not thought much about before. But mostly, I just felt grateful. Grateful for good neighbors, grateful for a fair legal system, grateful for a judge who cared about justice, and grateful that I could pile snow on my own property without fear of harassment. The next winter brought record snowfall to Rochester. I spent hours with my snowblower, clearing my driveway and sidewalks. The snow pile grew enormous, easily 10 feet tall and 20 feet across. I could see it from my front window, a monument to property rights and common sense. Tim sent me a text with a photo of the pile and a laughing emoji. The legend continues. I smiled and typed back, just a man and his snow pile living their best life. Months turned into years. The neighborhood thrived under the new board's leadership. Property values increased. More families moved in. The annual neighborhood events became tradition. And every winter, I built my snow pile in the same spot. And every winter, the neighborhood kids used it as a sledding hill. Sometimes people would move into the neighborhood and ask about the unusually large snow pile on my property. The older residents would smile and say, "Oh, that's Yates's pile. There's a story behind that." And they would tell the tale of Karen, the lawsuit, the trial, and the neighborhood uprising that followed. The story took on a life of its own, becoming part of neighborhood lore. Details got exaggerated or changed with each retelling, but the core message remained. Stand up for yourself, know your rights, and never underestimate the power of a community united against unreasonable authority. I ran into Officer Mark Harrison at a coffee shop one morning. He recognized me and came over to chat. "Hey Yates, I heard you're still building that snow pile every year." "Tradition now," I said with a grin. "Good for you. That whole situation was ridiculous from the start. I'm glad it worked out in the end." "Me too." "Thanks for writing an honest report, by the way. It made all the difference." "Just doing my job. But between you and me, I've never understood why people get so worked up over HOAs. Life's too short to spend it measuring your neighbor's grass height." I could not have said it better myself. As I drove home that day, I passed by the community center where so many HOA meetings had been held. The sign out front advertised an upcoming neighborhood barbecue and movie night. Inside, I knew, the current board was probably discussing actually important matters like repaving the community pool parking lot or organizing the summer concert series. No one was arguing about snow piles or mailbox colors. No one was threatening lawsuits or levying ridiculous fines. The HOA was doing what it was supposed to do, maintaining common areas, organizing community events, and staying out of homeowners' way unless there was a genuine issue. It seemed like such a simple concept, yet it had taken a crisis to get there. I pulled into my driveway and sat for a moment, looking at my house. It was just a normal 3-bedroom ranch, nothing special, but it was mine. The grass was mowed to a reasonable height. The paint was in good condition. The mailbox, still that slightly wrong shade of black that had once earned me a violation notice, stood proudly at the curb. And in the winter, there would be a snow pile. A big, glorious, completely legal snow pile on my own property, built with my own snow, enjoyed by my neighbor's children, and representing everything I had learned about standing up for what was right. Karen was gone. Donald was gone. The old board was a memory, but the lessons remained. I got out of the car and headed inside, already thinking about dinner and maybe catching a baseball game on TV. Life was good. Life was normal. And I had a snow pile to look forward to next winter. The end of the saga brought clarity about what mattered. Community was not about enforcing petty rules or exercising power over others. It was about people coming together, respecting each other's space and rights, and working toward common goals that benefited everyone. That night, I got an email from Michelle about the upcoming election for board positions. Several of the Reform Coalition members were running for re-election, and she was asking for endorsements from homeowners who had been satisfied with their performance. I wrote back immediately, praising the board's work and offering my full support. Then I did something I had never done before. I volunteered to help with the election campaign. If the past 2 years had taught me anything, it was that involvement mattered. You could not just sit back and hope reasonable people stayed in charge. You had to participate. Over the following weeks, I spent several evenings helping prepare campaign materials and talking to neighbors about the importance of voting. It felt good to be part of something positive, to channel all the energy that had gone into fighting the lawsuit into building something better. Election day came and went with another strong turnout. The Reform Coalition candidates won again, though not quite as dramatically as before. Some people always voted for change regardless of circumstances, and a few candidates who promised stricter enforcement of rules garnered some support from homeowners who genuinely wanted that. But the reasonable voices prevailed, and I felt confident the neighborhood was in good hands. As summer turned to fall and fall gave way to winter once more, I found myself actually looking forward to building my snow pile again. It had become more than just a practical matter of snow disposal. It was a symbol of autonomy and a reminder that rights, once defended, should never be taken for granted. The first major snowstorm of the season arrived in early December. I was out with my snowblower at 6 in the morning, clearing paths and starting the foundation of what would become this year's pile. My neighbors were doing the same, and we waved to each other as we worked in the pre-dawn darkness. By the time the sun came up, my pile was already 4 feet tall and growing. I could see kids from down the street eyeing it with anticipation. Another month or two of winter storms and it would be prime sledding height. Tim came over with his snowblower to help clear the sidewalk in front of both our houses, getting an early start on the pile. He called over the sound of the machines. Might as well, I called back. Weather service says we're getting another storm on Wednesday. Make it big this year. The kids are already talking about it. I grinned. Always do. As we worked side by side, clearing snow and piling it carefully on my property, well within the boundaries that had been so meticulously measured and defended. I thought about how strange life could be. A simple accident had spiraled into a legal battle, neighborhood upheaval, and eventually, positive change. Karen's attempt to make me pay for her mistake had backfired spectacularly, costing her money, reputation, and eventually her position in the neighborhood. Meanwhile, I was still here, building my snow pile, living my life, and enjoying the community that had rallied around a simple principle. People should be able to do what they wanted on their own property as long as they were not hurting anyone else. It was not complicated. It should never have required lawyers and judges and trials. But sometimes, that is what it took to defend basic rights against people who thought their authority trumped everything else. The snow pile grew throughout December and into January. By mid-January, it was over 12 feet tall, the largest I had ever built. Kids came from several streets over to sled down it. Parents stood around chatting while their children played, and more than once I heard someone tell the story of how the pile had become a neighborhood institution. I never got tired of hearing it. Each retelling was slightly different, with various details emphasized or embellished, but the core truth remained. Karen crashed into my snow pile, sued me, and lost spectacularly because the pile was on my property and she had been the one at fault all along. It was a simple story about simple facts, but it resonated because everyone could understand the fundamental fairness of it. We all knew what it felt like to be blamed for something that was not our fault. We all knew the frustration of dealing with someone who refused to admit they were wrong. And we all appreciated seeing justice served when someone finally stood up and fought back. On a particularly cold Saturday in late January, the neighborhood organized an informal sledding party at my snow pile. Someone brought hot chocolate. Someone else brought cookies. Kids raced down the pile on sleds, saucers, and pieces of cardboard while adults stood around bundled in winter coats, watching and laughing. Michelle came over with her family. "You know, this pile has become the heart of the neighborhood in winter," she said. "Who would have thought?" "Karen, probably, if she had known how it would turn out," I replied with a laugh. "You ever think about her? Wonder what she's doing now?" I considered the question. "Honestly, not really. I hope she's doing okay and maybe learned something from the experience. But mostly, I'm just glad it's over and we all moved on." "That's healthier than I would be," Michelle admitted. "I think I would still be angry. I was angry for a long time, but anger is exhausting. At some point, you have to let it go and focus on the good stuff." We watched the kids play for a while longer, the sound of their laughter cutting through the cold air. This was the good stuff: community, friendship, simple joys. A pile of snow that brought people together instead of tearing them apart. As the sun began to set and families started heading home, I stood alone by the pile for a moment, just taking it all in. The snow was already starting to melt slightly in the afternoon sun, which meant it would freeze overnight and become even better for sledding tomorrow. I thought about everything that had happened since that January morning when Karen crashed into the first version of this pile. The stress, the legal fees, the meetings, the trial, the eventual victory, and the neighborhood transformation that followed. It had been a journey I never wanted to take and would never want to repeat, but I could not deny that some good had come from it. The neighborhood was better. The HOA was better. People were more engaged and aware of their rights. And I had learned that standing up for principle, even when it was difficult and expensive, was worth it in the end. As I walked back to my house, boots crunching through the snow, I felt a sense of peace. The saga of Karen and the snow pile was over, but its legacy continued. Every winter, the pile would rise again, a frozen monument to common sense, property rights, and the power of a community that refused to be pushed around. And that, I thought, was exactly how it should be. life continued its normal rhythm. Work, weekends, bills, and snow piles. The extraordinary had become ordinary again, which was exactly what I wanted. I had never sought attention or conflict. I just wanted to live my life, maintain my property, and be left alone to do so. The snow pile eventually melted with the arrival of spring, leaving behind only muddy ground that would soon turn green again. The sledding hill was gone, but the memories remained, and everyone knew that next winter would bring another pile, another gathering place, another reminder of the year we stood up to unreasonable authority, and won. I never sued the HOA for the additional harassment, or tried to extract more money from Karen beyond what the judge awarded. I could have pushed further, made more trouble, turned the whole thing into an even bigger crusade. But that was not who I was. I had fought for what was right, won, and now it was time to move on. The years that followed were peaceful. The HOA continued functioning smoothly under reasonable leadership. Property values in Meadowbrook Hills increased steadily. New families moved in, attracted by the strong sense of community they heard about when researching the neighborhood. Every year I built my snow pile. Every year the kids sledded down it, and every year someone would ask about it and hear the story. It became part of my identity in the neighborhood. I was Yates, the guy with the snow pile, the guy who stood up to the HOA and won. It was not how I had planned to be known, but there were worse reputations to have. Sometimes, late at night when I could not sleep, I would think about Karen and wonder what she was doing. Had she learned anything? Did she ever think about the lawsuit and regret her choices? Or did she still believe she had been right and everyone else had been wrong? I would never know, and ultimately it did not matter. Her choices had led to her consequences. My choices had led to mine. We had both moved on with our lives, hopefully a little wiser for the experience. The snow pile was just a pile of snow. But it represented so much more. The right to use your own property as you saw fit, the importance of standing up to bullies, the value of community support, and the ultimate fairness of a legal system that, despite its flaws, could deliver justice when presented with clear facts. These were lessons worth remembering, worth sharing, and worth defending every single winter when I fired up my snowblower and started piling snow in that same spot on my property where Karen had crashed all those years ago. And so the story ended not with drama or conflict, but with the quiet satisfaction of an ordinary life well lived, battles fought and won, and the simple pleasure of watching neighborhood children sled down a hill that should never have been anything more than what it was. A pile of snow on a man's own property, exactly where it belonged.